So you're going through a contentious divorce case and your case has just been set for trial. What can you expect at trial? I'm Gerald Maggio, Southern California divorce and family law attorney, and in this video I'm going to explain the process of how you get to trial, what happens during trial, and what you can expect after your trial is done. If a case is going to trial in a California divorce case, that means the parties have been unable to come to a resolution in their case through mediation, alternative dispute resolution, or negotiations. Going to trial can be a complex and time-consuming process, and so it's important to understand what that process is, and also to understand that you should only use trial as a last resort because it's very time-consuming and costly. Number one, pre-trial procedures. What do I mean by that? Well, before you get to trial, there's usually something called discovery, which is producing documents and responding to certain questions, subpoenas, depositions, that type of discovery processes. That can happen on both sides. There can be motions that lead up to trial that affect trial. There are a variety of procedures that can happen before your case ever gets to trial. Number two, trial preparation. To get to trial, to get ready for trial, requires that the parties and the attorneys work together to do extensive trial preparation. That can be preparation of exhibits, exhibit lists, witness lists, prepping the parties for testimony, talking to third-party witnesses that will be used in your case. There's a whole host of work that can be done. It's quite extensive, can take a lot of time, and usually is going to require that the client work with the attorney or attorneys to come up with the best strategy for trial and to be fully prepared to get the best possible outcome. Number three, presenting evidence. When you actually get to trial, that's where you're going to put your case on. And that means your attorney is going to be working with you to help present evidence. And evidence can be testimony of a party, it can be a testimony of a witness, it can include documentary evidence, that can include documents, it can include pictures, text messages, photographs, a whole host of things that you really need to work with your attorney, because it's really important to nail what is going to be presented as evidence, how it's going to be presented in the most effective way to get the best outcome in your trial. Number four, examination and cross-examination. In a trial, attorneys are going to be calling witnesses to testify. If they're calling on behalf of their case, that's generally called direct examination, where they're asking questions to get information out to the court so the court can make a decision in the end. And so that's asking questions of that witness. The other side has the opportunity to cross-examine that witness, that party, who be it, to go through and basically attack that person's credibility if that witness is not helpful for their case. That's where they can add leading questions and basically try to trip them up and hurt their credibility. Number five, legal argument. Once the parties have presented their cases on both sides, the court's going to ask, do you rest counsel? Do you rest counsel on the other side? Once the court has done that, and the parties have agreed and say that their case, they rest on their case, the next step is legal arguments, which is where your attorney is going to be tying in all the evidence to say, this is what the evidence shows. This is why the court should be ruling in this manner. Once the court has heard the legal arguments of both parties, that's where judicial decision-making comes in. That's when the court's going to have to consider all of what it's heard, consider all the evidence that's been presented, the testimony, the closing arguments, all of that, and then make a decision that is based on what the court thinks that evidence holds true. After the trial is concluded and the court makes its decision and issues its ruling, that ruling is generally going to need to be incorporated into something called a judgment, which is where the formal orders that have been worked out are put into writing based on what the court ordered, and that's called a judgment, which will then be sent to the other side that did not prepare the judgment for approval to make sure that they agree on what the judge in fact ordered, and then they will get that signed, and then that's submitted to the court, and the court will then process it, and then it becomes the formal order of the court at that point. And if it's part of a divorce judgment, that's usually when you're also going to be considered divorced as part of the same process. After a final judgment has been submitted to the court and filed, there sometimes can be post-trial procedures that happen. This can often happen when somebody's not abiding by the court orders made in the judgment, and that's where contempt actions and other proceedings to enforce the judgment can happen. The bottom line is that both parties need to comply with the court's orders to avoid these post-judgment procedures. If a party feels that the court has made a decision that is wrong, they should certainly talk to their attorney, because the attorney is going to make a determination here of whether an appeal should happen. And an appeal is where that party that feels aggrieved believes that the court acted outside its discretion. Basically, the judge exceeded the discretion that it has in making the decision that it did. The appeal process can be complex. Many family law attorneys don't do appeals. Generally, it's a much smaller group of attorneys that do that. And finally, closure of the case. If everything's been done, including an appeal if it's determined that that's something a party wants to pursue. Otherwise, if the case is done, basically the attorneys usually file a withdrawal of the case because they're done with their work on the case, and the parties simply need to abide by the terms of the judgment. Both parties should always consider divorce to be a last resort. That's what the court is there for. But you're always better off, if you can, to resolve your case by mediation or simply just negotiating with the other side to come up to a resolution. That's always something that should be done on a regular basis in these type of cases before you have to go to trial. If you or somebody you know is going through a divorce, feel free to have them contact us for a free consultation where we'll explain what your legal rights are and explain possible next steps in your case. If you like this video, feel free to subscribe to our YouTube channel at the end of this video for more helpful information about divorce and family law issues. See you next time.